Hi, I'm Renee Osipov with Chelle Law, and we assist nurse practitioners with employment contract issues. Today, I'm addressing a question that we get frequently. Is a non-compete enforceable against a nurse practitioner? So this kind of depends on several factors, but first let's start with what actually is a non-compete. So a non-compete clause is normally located in your restrictive covenants within your employment agreement. So the non-compete clause is just going to state that for a period of time, it's normally anywhere from 1 to 3 years, you're restricted from working in a certain area. And normally it's within miles. Depending on your state law, it might be a little bit different how that restricted area is calculated. But for that period of time, you're restricted from that area, from working in that area so that you're not competing with your former employer. Non-compete clauses can get really complicated and they're very unique to sort of each situation. So sometimes it is difficult to know if it's actually enforceable. I also think there's a lot of misconceptions out there that, if a non-compete clause is stated a certain way that it's unenforceable and you can get out of it. It's pretty difficult, I would actually say, to get out of a non-compete clause that you have signed. Now, if we're talking about at the beginning when you're negotiating, it's much easier to negotiate your non-compete clause. But if you are currently employed, you are giving notice to terminate your employment, and you want out of your non-compete clause then, or you want to know if it's enforceable, this gets a little complicated. And I would always advise everyone to meet with an attorney and have attorney review your documents just so that you make sure, because you can have serious consequences. If your non-compete clause is enforceable and you violate it, there's really two types of legal remedies. So the first one, it's normally listed in your employment contract. This is the most common way. It's under Equitable Relief. What this means is that if you violate your non-compete clause, your former employer can take you to court, or it's normally court, for equitable relief. A judge would look at the contract, and if it's enforceable, they would sign something which is actually like a restraining order or an injunction saying that you cannot work in that area, and you may have to pay for those legal fees. I also have seen contracts where there are liquidated damages, and what that means is if you violate the non-compete clause, your employer can ask you to reimburse them for tens of thousands of dollars. So it's pretty serious. So you want to make sure if you're going to violate it, you really need to know if it actually is enforceable. And even furthermore, even if it isn't enforceable, I would highly recommend advising an attorney because you did sign that employment agreement, and therefore your employer, may try to fight this with you, and that can be expensive in legal fees. So you always want to be really careful. Now, going back to, is it enforceable, a non-compete? If you are in a state which has a law, it is becoming more common. There's about 3 of them that do not allow contracts or do not allow your employer to enforce a non-compete clause. So if you're in one of those states, that's great. It's not enforceable. You should always check your state law, though, just to make sure. Now, there is a new trend that I'm seeing some laws going into effect that a non-compete clause is unenforceable if you make below a certain amount of money annually. So you want to check your law there, and you want to see, how much you're making. Is it more than that threshold? If it is more, it may include bonuses, so you want to be really careful, then the non-compete's enforceable. So state law is going to be the first place you should look. If your state law does allow for non-compete clauses, most of them they're enforceable as long as they're reasonable. Reasonable is extremely vague, and it's really hard to give clients an exact number of miles or exact number of years. But normally, there is some discretion there, so you want to be careful. If it's over 3 years, in my opinion, then it's probably unreasonable for the time period. And then also if it's, wiping out huge areas of a state or even an entire state, something like that, that would likely be unreasonable. But again, you really want to be careful. Most of the time they are enforceable. And so you want to be careful. You want to protect yourself and you want to make sure you're definitely doing your research and your due diligence to know if it's something that you should be concerned about. Now, you can also ask your employer to be let out of your non-compete clause. You are kind of at their mercy there if they're going to waive that for you. If they ever state that they do, it should really be in writing and signed by both parties. Sometimes I've also seen you can buy out of your non-compete clause. So your employer will say, we will waive this agreement if you pay us a certain amount of money. It's normally pretty high, but that's something that you could negotiate. So there are some ways around it. But if you signed it and it would be considered reasonable in the court's eyes, then, and your state law, then yes, it would be enforceable. So you always want to be careful when you're terminating your employment contract to make sure that you know if you're going to be violating that non-compete clause. If you'd like more information, you can check out our website at Chelle Law, CHELLE law.com. Our contact information is in there as well. We're happy to set up a consultation with one of our attorneys. You can send us your employment agreement. We can definitely take a look at those non-compete clauses. Thanks.